New Jersey real estate exam questions. Question 1. In a brokerage file review, a person wants to qualify for a New Jersey real estate salesperson license. Which requirement must the applicant meet before licensure? Option A. Pass the exam first and then decide later whether to affiliate with any broker. Option B. Complete 150 hours of broker education and open an independent office. Option C. Complete the 75-hour pre-licensure course, pass the exam, and apply through a sponsoring broker. Option D. Take only a continuing education course after receiving a license. The correct answer is option C. Complete the 75-hour pre-licensure course, pass the exam, and apply through a sponsoring broker. A New Jersey salesperson applicant must satisfy education, examination, sponsorship, and character-related licensing requirements before practicing. Choice A is wrong because a salesperson license is issued through an employing or sponsoring broker. Choice B is wrong because that applies to broker-level preparation, not the basic salesperson license. And choice D is wrong because continuing education is for renewal, not initial salesperson qualification. Question 2. For a duplex in Trenton, an experienced salesperson asks what is required to become a New Jersey broker. Which combination best matches the broker eligibility path? Option A. 1 year of part-time sales experience and a 75-hour course. Option B. 3 years of full-time salesperson experience plus 150 hours of approved broker education. Option C. A referral license and 6 months of office work. Option D. A high school diploma only, if the applicant passes the state exam. The correct answer is option B. 3 years of full-time salesperson experience plus 150 hours of approved broker education. Broker candidates are held to a higher standard because they may supervise brokerage activity and handle office responsibilities. Choice A is wrong because that resembles entry-level salesperson preparation and does not satisfy broker experience requirements. Choice C is wrong because referral activity and office support do not replace the broker prerequisites. And choice D is wrong because education and approved experience are still required. Question 3. While preparing a listing package, a salesperson completes the pre-licensure course and receives examination eligibility. How long does that eligibility generally remain active? Option A. 30 days after the school certificate is issued. Option B. Indefinitely as long as the candidate keeps studying. Option C. 1 year from the date it is issued. Option D. 2 years after the course completion date. The correct answer is option C. 1 year from the date it is issued. New Jersey candidates must pass the examination and complete the licensing process within the applicable eligibility period. Choice A is wrong because that is too short for the standard eligibility period. Choice B is wrong because eligibility expires and does not remain open forever. And choice D is wrong because that overstates the eligibility window. Question 4. At a salesperson training session, a public complaint alleges that a licensee violated real estate licensing law. Which body has regulatory authority over New Jersey real estate licensees? Option A. The New Jersey Real Estate Commission. Option B. The Multiple Listing Service only. Option C. The Local Board of Education. Option D. The County Tax Assessor. The correct answer is option A. The New Jersey Real Estate Commission. The New Jersey Real Estate Commission administers and enforces the state licensing law and related professional standards. Choice B is wrong because an MLS may set membership rules but does not issue state licenses. Choice C is wrong because that agency does not regulate brokerage licenses. And choice D is wrong because tax assessment duties are separate from license discipline. Question 5. After receiving an offer in Princeton, an applicant has completed education and passed the exam but has a serious character issue on the application. Which principle controls the licensing decision? Option A. Passing the exam automatically guarantees a license. Option B. The commission must be satisfied with the applicant's honesty, trustworthiness, character, and integrity. Option C. Only the sponsoring broker decides whether the state issues the license. Option D. Character matters only after the first renewal. The correct answer is option B. The commission must be satisfied with the applicant's honesty, trustworthiness, character, and integrity. Real estate licensing protects the public, so New Jersey considers more than classroom completion and test performance. Choice A is wrong because examination success does not eliminate character review. Choice C is wrong because broker sponsorship is important but the commission makes licensing determinations. And choice D is wrong because character qualifications apply at initial licensure. Question 6. During an agency disclosure conversation, a new salesperson passes the exam and wants to start showing property immediately as an independent agent. Which action is required first? Option A. The candidate may practice alone for 90 days after passing. Option B. The candidate must complete licensure through an employing broker before practicing. Option C. The candidate may collect commissions directly from clients before sponsorship. Option D. The candidate can use a friend's broker license temporarily. The correct answer is option B. The candidate must complete licensure through an employing broker before practicing. A salesperson operates under a broker and cannot lawfully act independently before the licensing process is completed. Choice A is wrong because passing the exam is not the same as holding an active license. Choice C is wrong because compensation must flow through the proper brokerage relationship. And choice D is wrong because licenses are personal and cannot be borrowed. Question 7. In a compliance audit, a broker candidate wants to schedule the broker examination before state approval of experience. What should the candidate understand? Option A. The candidate may skip the certificate if the employing broker signs a letter. Option B. The candidate should wait for the certificate of examination eligibility before making the reservation. Option C. The candidate only needs a salesperson pocket card at the test center. Option D. The candidate may schedule first and submit experience later. The correct answer is option B. The candidate should wait for the certificate of examination eligibility before making the reservation. Broker examination eligibility is controlled by the Commission's review of education and experience. Choice A is wrong because a broker's letter does not replace the state eligibility certificate. Choice C is wrong because broker candidates need the required eligibility documentation. And choice D is wrong because broker candidates must be approved before making the broker exam reservation. Question 8. When reviewing closing papers, a salesperson receives a referral fee offered directly from a mortgage lender for sending a buyer. How should the salesperson respond? Option A. Deposit the fee into a personal account and disclose it later. Option B. Ask the lender to label the payment as a gift. Option C. Accept the payment personally if the buyer consents. Option D. Refuse direct compensation and follow compensation rules through the employing broker. The correct answer is option D. Refuse direct compensation and follow compensation rules through the employing broker. A salesperson's real estate compensation must be handled through the supervising broker and cannot be taken directly from outside parties. Choice A is wrong because personal receipt of unauthorized compensation violates compensation rules. Choice B is wrong because renaming compensation does not cure an improper payment. And choice C is wrong because buyer consent does not authorize compensation outside the broker relationship. Question 9. Before meeting a client in Asbury Park, a broker is reviewing supervision duties for affiliated salespersons. Which statement best describes the broker's responsibility? Option A. Salespersons supervise themselves once licensed. Option B. The broker must supervise licensed activity performed through the brokerage. Option C. Only the office manager is responsible for legal compliance. Option D. Supervision applies only to commercial deals. The correct answer is option B. The broker must supervise licensed activity performed through the brokerage. A broker is responsible for the brokerage operation and for ensuring affiliated licensees follow applicable law and office procedures. Choice A is wrong because salespersons act under broker supervision. Choice C is wrong because delegation does not remove the broker's responsibility. And choice D is wrong because broker supervision covers brokerage activity generally. Question 10. During a transaction in Montclair, a buyer gives earnest money to a listing broker in a purchase transaction. Where should money belonging to others be placed? Option A. In the salesperson's desk until closing. Option B. In the seller's account before acceptance. Option C. In the broker's personal checking account. Option D. In a separate broker escrow or trust account maintained for funds of others. The correct answer is option D. In a separate broker escrow or trust account maintained for funds of others. Trust funds must be safeguarded separately from the broker's personal and operating funds. Choice A is wrong because a salesperson should promptly account for and deliver funds to the broker. Choice B is wrong because the seller is not automatically entitled to the buyer's deposit before proper disbursement. And choice C is wrong because that would mix client funds with personal money. Question 11. In a brokerage file review, a deposit is received while negotiations are expected to continue beyond 5 business days. How should the licensee handle the money? Option A. Hold it uncashed until all negotiations are finished. Option B. Give it to the listing salesperson for safekeeping. Option C. Deliver it to the broker so it can be deposited into the trust account within the required time. Option D. Deposit it into the broker's operating account. The correct answer is option C. Deliver it to the broker so it can be deposited into the trust account within the required time. When negotiations continue beyond the short statutory window, funds of others must be promptly segregated into the broker's trust account. Choice A is wrong because ongoing negotiations do not allow indefinite personal holding of the deposit. Choice B is wrong because salespersons do not maintain trust accounts for client deposits. And choice D is wrong because operating accounts are not trust accounts for money of others. Question 12. For a duplex in Jersey City, a broker places client earnest money into the same account used to pay office rent. Which violation is most directly shown? Option A. Commingling. Option B. Redlining. Option C. Blockbusting. Option D. This cheat. The correct answer is option A. Commingling. Commingling occurs when money of others is mixed with the broker's own business or personal funds. Choice B is wrong because redlining involves discriminatory lending or service patterns by area. Choice C is wrong because blockbusting involves inducing panic selling based on protected class changes. And choice D is wrong because a cheat is the government's power to take property when an owner dies without heirs. Question 13. While preparing a listing package, a broker intentionally uses escrow funds to pay a personal credit card bill. Which violation best describes this conduct? Option A. Conversion. Option B. Novation. Option C. Accretion. Option D. Variance. The correct answer is option A. Conversion. Conversion is the wrongful taking or use of another person's money or property for one's own purpose. Choice B is wrong because novation replaces a party or obligation in a contract and is not misuse of funds. Choice C is wrong because accretion is a gradual addition to land by natural forces. And choice D is wrong because a variance is zoning relief, not taking another person's money. Question 14. At a salesperson training session, a broker is authorized to take a commission from trust funds after it is earned. What must the broker do to avoid commingling? Option A. Leave the commission in escrow as a savings reserve. Option B. Pay the commission directly to the salesperson from escrow. Option C. Transfer all trust funds to the operating account. Option D. Withdraw the commission from the trust account within the required time after it becomes payable. The correct answer is option D. Withdraw the commission from the trust account within the required time after it becomes payable. Once money becomes the broker's earned commission, it should not remain in the trust account as though it were still client money. Choice A is wrong because earned broker funds should not remain mixed with trust funds. Choice B is wrong because salesperson compensation should be handled through the brokerage's proper accounting process. And choice C is wrong because client funds cannot be moved improperly to a business account. Question 15. After receiving an offer in Camden, a licensee has an ownership interest in property being sold through the brokerage. What disclosure is required? Option A. Disclosure is needed only after closing. Option B. No disclosure is needed if the price is fair. Option C. The licensee's interest should be disclosed to the purchaser in the contract of sale. Option D. Only the lender needs to know. The correct answer is option C. The licensee's interest should be disclosed to the purchaser in the contract of sale. A licensee acting as a principal or having an ownership interest must disclose that conflict so the other party can make an informed decision. Choice A is wrong because the buyer must know before being bound to the transaction. Choice B is wrong because fair price does not remove the conflict of interest. And choice D is wrong because the purchaser is the party affected by the licensee's ownership interest. Question 16. During an agency disclosure conversation, a salesperson wants to advertise a property exclusively listed by another brokerage. Which condition must be satisfied first? Option A. No consent is required for social media posts. Option B. The salesperson may advertise it if the price is public. Option C. Prior written consent from the listing broker must be obtained. Option D. Consent from any buyer is enough. The correct answer is option C. Prior written consent from the listing broker must be obtained. Exclusive listings cannot be advertised by another brokerage without proper authorization from the listing broker. Choice A is wrong because online advertising is still advertising subject to the rules. Choice B is wrong because public price information does not authorize another broker's advertising. And choice D is wrong because the listing broker controls the exclusive listing advertising permission. Question 17. In a compliance audit, a salesperson creates a social media ad for a listing. Which identification should appear in the advertisement? Option A. Only the salesperson's nickname. Option B. Only a personal cell phone number. Option C. The salesperson's licensed name and the regular business name of the broker through whom the salesperson is licensed. Option D. Only the property address. The correct answer is option C. The salesperson's licensed name and the regular business name of the broker through whom the salesperson is licensed. New Jersey advertising rules require clear identification of the licensed person and the brokerage business name. Choice A is wrong because ads must identify the licensed individual and broker appropriately. Choice B is wrong because contact information alone does not satisfy brokerage identification rules. And choice D is wrong because property information does not identify the brokerage authority. Question 18. When reviewing closing papers, a salesperson's advertisement shows the salesperson name in huge type and the broker's name in small print. Which issue is raised? Option A. The broker's regular business name must appear more prominently than the non-broker licensee's name. Option B. The ad is valid because the salesperson paid for it. Option C. The ad is valid if the property sells quickly. Option D. The ad is invalid only if it contains a price. The correct answer is option A. The broker's regular business name must appear more prominently than the non-broker licensee's name. Advertising must make the brokerage relationship clear to the public rather than presenting a salesperson as the brokerage. Choice B is wrong because payment for an ad does not change the prominence rule. Choice C is wrong because sales success does not cure an advertising violation. And choice D is wrong because the broker identification rule is not limited to price advertisements. Question 19. Before meeting a client in Morristown, an ad states that the brokerage is licensed by the New Jersey Real Estate Commission. What additional message is generally required? Option A. A clear statement that licensure does not imply endorsement. Option B. A promise that the commission guarantees the property condition. Option C. A notice that the salesperson is an attorney. Option D. A statement that commissions are fixed by law. The correct answer is option A. A clear statement that licensure does not imply endorsement. A reference to commission licensure cannot be presented as though the state endorses the licensee's services. Choice B is wrong because the commission does not guarantee listed property quality. Choice C is wrong because attorney status is unrelated unless it is actually true and relevant. And choice D is wrong because commission rates are not fixed and such a claim would be misleading. Question 20. During a transaction in Edison, an advertisement mentions the brokerage's commission rate. Which statement should also be included in New Jersey? Option A. In New Jersey, commissions are negotiable. Option B. Only sellers may negotiate commission. Option C. All commissions are set by the Real Estate Commission. Option D. Commission is due even if no brokerage agreement exists. The correct answer is option A. In New Jersey, commissions are negotiable. New Jersey requires transparency when commission rates or fees are advertised so consumers are not misled into believing rates are fixed. Choice B is wrong because compensation arrangements may involve different parties depending on the agreement. Choice C is wrong because commission rates are not government fixed. And choice D is wrong because compensation depends on the applicable agreement and law. Question 21. In a brokerage file review, a referral agent prepares marketing materials for the public. Which limitation should be made clear? Option A. The referral agent may hold escrow deposits. Option B. The referral agent may negotiate contracts alone. Option C. The services are limited to referring prospects to a broker. Option D. The referral agent may supervise salespersons. The correct answer is option C. Services are limited to referring prospects to a broker. A referral license is limited and should not be presented as full brokerage representation. Choice A is wrong because referral status does not authorize trust fund handling. Choice B is wrong because negotiation is licensed brokerage activity beyond referral-only status. And choice D is wrong because supervision is a broker-level responsibility. Question 22. For a duplex in Montclair, an unlicensed assistant is asked to host an open house, answer price questions, and negotiate offers. Which task creates the greatest licensing problem? Option A. Negotiating offers with buyers or sellers. Option B. Ordering office supplies. Option C. Scheduling a showing without giving advice. Option D. Typing a broker-approved flyer. The correct answer is option A. Negotiating offers with buyers or sellers. Negotiating real estate terms is licensed brokerage activity and cannot be performed by an unlicensed assistant. Choice B is wrong because clerical purchasing does not require a real estate license. Choice C is wrong because ministerial scheduling is different from negotiation. And choice D is wrong because pure clerical support can be permissible when properly supervised. Question 23. While preparing a listing package, a broker is deciding how long transaction files and escrow records should be kept. Which compliance principle is most important? Option A. Maintain required records so the commission can review brokerage activity and trust accounting. Option B. Destroy records immediately after commission is paid. Option C. Keep only text messages but no contracts. Option D. Let each salesperson keep the only file copy. The correct answer is option A. Maintain required records so the commission can review brokerage activity and trust accounting. Record keeping supports supervision, audits, consumer protection, and proof of proper handling of funds and documents. Choice B is wrong because paid commission does not end record keeping duties. Choice C is wrong because contracts and financial records are central brokerage documents. And choice D is wrong because brokerage records must be under responsible brokerage control. Question 24. At a salesperson training session, a broker's trust ledger does not match the bank balance and no reconciliation is performed. Which area is most directly at risk? Option A. Land measurement. Option B. Zoning variance approval. Option C. Escrow account bookkeeping compliance. Option D. Appraisal licensing. The correct answer is option C. Escrow account bookkeeping compliance. Trust account records must accurately track client funds so shortages, overages, and improper disbursements can be detected. Choice A is wrong because survey or measurement issues are unrelated to trust ledger accuracy. Choice B is wrong because local land use relief is not the same as broker trust accounting. And choice D is wrong because value opinions do not correct escrow bookkeeping failures. Question 25. After receiving an offer in Patterson, a consumer loses money because a licensee unlawfully converts funds in a brokerage transaction. Which New Jersey protection may be relevant? Option A. The Real Estate Guarantee Fund. Option B. A homeowners association reserve. Option C. A zoning board escrow. Option D. Private mortgage insurance. The correct answer is option A. The Real Estate Guarantee Fund. The Real Estate Guarantee Fund provides a potential recovery source for certain losses caused by embezzlement, conversion, or unlawful obtaining of property in brokerage transactions. Choice B is wrong because association reserves are for community expenses, not brokerage misconduct claims. Choice C is wrong because zoning boards do not reimburse brokerage fraud losses. And choice D is wrong because PMI protects a lender against borrower default, not a consumer from licensee conversion. Question 26. During an agency disclosure conversation, a developer markets out-of-state subdivision interests to New Jersey purchasers. Which New Jersey law is most likely relevant? Option A. The New Jersey Real Estate Sales Full Disclosure Act. Option B. The Equal Credit Opportunity Act only. Option C. The Truth in Renting Act only. Option D. The Farmland Assessment Act only. The correct answer is option A. The New Jersey Real Estate Sales Full Disclosure Act. The Real Estate Sales Full Disclosure Act regulates certain real estate offerings marketed in New Jersey, including interests located outside the state. Choice B is wrong because ECOA addresses credit discrimination, not registration of out-of-state offerings. Choice C is wrong because that law concerns rental disclosures rather than marketing subdivided land interests. And choice D is wrong because farmland assessment deals with property tax treatment. Question 27. In a compliance audit, a landlord refuses to rent to an otherwise qualified applicant because the applicant uses a lawful housing voucher. Which New Jersey rule is implicated? Option A. The rule of capture. Option B. The New Jersey law against discrimination protection for lawful source of income or rent payment. Option C. The statute of frauds only. Option D. The rule against fixtures. The correct answer is option B. The New Jersey law against discrimination protection for lawful source of income or rent payment. New Jersey fair housing protections include lawful source of income or rent payment in housing transactions. Choice A is wrong because that doctrine concerns natural resources, not rental screening. Choice C is wrong because contract writing rules do not authorize source of income discrimination. And choice D is wrong because fixture law concerns personal versus real property, not discrimination. Question 28. When reviewing closing papers, an agent guides buyers away from a neighborhood because of the buyer's national origin. Which prohibited practice is this? Option A. Defeasance. Option B. Steering. Option C. Puffing. Option D. Accession. The correct answer is option B. Steering. Steering occurs when a housing professional directs or limits choices because of a protected characteristic. Choice A is wrong because defeasance is a mortgage clause, not fair housing misconduct. Choice C is wrong because puffing is exaggerated opinion and does not describe directing buyers based on protected status. And choice D is wrong because accession concerns ownership of added property, not discriminatory guidance. Question 29. Before meeting a client in Princeton, a licensee tells homeowners that people of a certain protected class are moving nearby and they should sell quickly. Which violation is shown? Option A. Redemption. Option B. Assemblage. Option C. Blockbusting. Option D. Subordination. The correct answer is option C. Blockbusting. Blockbusting uses fear or prejudice to induce sales or listings and is prohibited under fair housing principles. Choice A is wrong because redemption concerns reclaiming property after default or foreclosure in certain contexts. Choice B is wrong because assemblage combines parcels and is not a fair housing violation. And choice D is wrong because subordination changes lien priority and is not panic selling. Question 30. During a transaction in Atlantic City, a lender refuses to make loans in neighborhoods with high minority populations regardless of applicant qualifications. Which term best describes this conduct? Option A. Hypothecation. Option B. Prioration. Option C. Redlining. Option D. Reconciliation. The correct answer is option C. Redlining. Redlining is the discriminatory denial or restriction of credit or services based on neighborhood characteristics tied to protected classes. Choice A is wrong because hypothecation pledges property as security while retaining possession. Choice B is wrong because prioration divides expenses at closing and does not describe lending discrimination. And choice D is wrong because reconciliation is an appraisal step, not discriminatory lending geography. Question 31. In a brokerage file review, a landlord refuses to rent to families with children unless the property qualifies for a lawful senior housing exception. Which protected category is involved? Option A. Subrogation. Option B. Tenancy in common. Option C. Familial status. Option D. Accretion. The correct answer is option C. Familial status. Familial status protects households with children from discriminatory housing treatment unless a narrow legal exception applies. Choice A is wrong because subrogation is an insurance concept, not discrimination law. Choice B is wrong because that is an ownership form, not a fair housing class. And choice D is wrong because accretion concerns land created by natural deposits. Question 32. For a duplex in Edison, a tenant with a disability requests permission to keep an assistance animal despite a no-pets policy. Which response is most consistent with fair housing principles? Option A. Charge a higher security deposit solely because of the disability. Option B, evaluate the request as a reasonable accommodation rather than automatically denying it as a pet violation. Option C, approve only if every tenant votes yes. Option D, deny it because all animal requests are identical to pet ownership. The correct answer is option B. Evaluate the request as a reasonable accommodation rather than automatically denying it as a pet violation. A disability-related accommodation may require an exception to ordinary rules when it is reasonable and necessary. Choice A is wrong because differential charges based on disability can be discriminatory. Choice C is wrong because fair housing rights are not subject to a popularity vote. And choice D is wrong because assistance animal requests can be disability accommodations. Question 33. While preparing a listing package, a seller asks the listing agent not to disclose a known structural defect to buyers. Which duty is most important? Option A, material facts and known defects should be disclosed as required by law and professional duties. Option B, follow the seller's instruction because loyalty always overrides disclosure. Option C, wait until after closing to mention the defect. Option D, disclose only to the appraiser and not to buyers. The correct answer is option A. Material facts and known defects should be disclosed as required by law and professional duties. Licensees owe honesty and disclosure duties that prevent concealment of material property facts. Choice B is wrong because loyalty does not permit concealment of material facts. Choice C is wrong because post-closing disclosure is too late for informed buyer decision-making. And choice D is wrong because buyers are directly affected by the property condition. Question 34. At a salesperson training session, an agent representing a seller also wants to represent the buyer in the same transaction. What is generally required for disclosed dual agency? Option A, only the seller's verbal permission. Option B, informed consent from both parties after proper disclosure. Option C, no consent because dual agency is always automatic. Option D, a lender's approval instead of client consent. The correct answer is option B, informed consent from both parties after proper disclosure. Dual agency creates divided loyalty, so both parties must understand and consent to the relationship. Choice A is wrong because both clients are affected by dual representation. Choice C is wrong because dual agency is not automatic and requires disclosure and consent. And choice D is wrong because lender approval does not replace the parties' informed agency consent. Question 35. After receiving an offer in Newark, two agents in the same brokerage are assigned separately to a buyer and a seller with appropriate consent. Which relationship is being used? Option A, novation. Option B, redlining. Option C, designated agency. Option D, tenancy et sufferance. The correct answer is option C, designated agency. Designated agency allows different licensees within one brokerage to represent different clients when the required disclosures and consents are handled. Choice A is wrong because novation replaces a party or obligation in a contract. Choice B is wrong because redlining is discriminatory lending or service practice. And choice D is wrong because that term describes occupancy after a lease ends, not brokerage representation. Question 36. During an agency disclosure conversation, a broker helps both sides with paperwork but does not advocate as either party's fiduciary. Which relationship best fits that limited role? Option A, life tenant. Option B, universal agent with unlimited authority. Option C, transaction broker or facilitator. Option D, mortgagee. The correct answer is option C, transaction broker or facilitator. A transaction broker or facilitator assists with the transaction without becoming a full fiduciary advocate for one party. Choice A is wrong because a life tenant holds a property interest, not a brokerage relationship. Choice B is wrong because a universal agent has broad authority that does not match a neutral facilitation role. And choice D is wrong because a mortgagee is the lender, not a neutral transaction facilitator. Question 37. In a compliance audit, a buyer asks whether a brokerage services agreement is needed before the licensee works with the buyer. Which answer best reflects current New Jersey consumer protection practice? Option A, only sellers can have brokerage agreements. Option B, an oral handshake is always enough. Option C, a written agreement is never needed for buyers. Option D, a written brokerage services agreement is generally required when providing brokerage services to the buyer. The correct answer is option D. A written brokerage services agreement is generally required when providing brokerage services to the buyer. Written brokerage agreements improve transparency about services, representation, and compensation before the licensee works with a buyer. Choice A is wrong because buyers may also enter brokerage service agreements. Choice B is wrong because consumer protection rules emphasize written disclosure and agreement. And choice C is wrong because current practice requires written agreements in buyer service situations. Question 38. When reviewing closing papers, a licensee owes obedience, loyalty, disclosure, confidentiality, accounting, and reasonable care to a client. Which concept is being tested? Option A, police power. Option B, this cheat. Option C, substitution. Option D, fiduciary duties. The correct answer is option D, fiduciary duties. Fiduciary duties define the high level of care and loyalty an agent owes to a client. Choice A is wrong because police power is government regulation for public welfare. Choice B is wrong because this cheat is a government right involving ownerless property. And choice C is wrong because substitution is not the standard term for client fiduciary obligations. Question 39. Before meeting a client in Camden, a licensee is working with a customer rather than a client. Which duty still applies? Option A, undivided loyalty as a fiduciary client. Option B, authority to sign contracts for the customer. Option C, honesty and fair dealing with disclosure of known material facts. Option D, permission to misstate property condition. The correct answer is option C, honesty and fair dealing with disclosure of known material facts. Even without a client fiduciary relationship, licensees must deal honestly and avoid concealing material information. Choice A is wrong because customers are not owed the full fiduciary loyalty owed to clients. Choice B is wrong because a licensee needs proper legal authority to sign for another person. And choice D is wrong because customer status does not allow misrepresentation. Question 40. During a transaction in Hoboken, a buyer submits an offer and the seller responds by changing the price and closing date. What is the seller's response? Option A, a counteroffer that rejects the original offer and proposes new terms. Option B, an appraisal report. Option C, an acceptance of the original offer. Option D, a deed restriction. The correct answer is option A, a counteroffer that rejects the original offer and proposes new terms. A counteroffer changes proposed terms and usually terminates the offeree's power to accept the original offer. Choice B is wrong because an appraisal estimates value and does not form contract terms. Choice C is wrong because changing material terms prevents the response from being an acceptance. And choice D is wrong because a deed restriction limits property use and is not an offer response. Question 41. In a brokerage file review, a valid real estate purchase contract is being reviewed. Which element is essential? Option A, only a handshake and a property photo. Option B, a notarized deed before any agreement. Option C, mutual assent, competent parties, lawful purpose, consideration, and sufficiently definite terms. Option D, an MLS number without parties or price. The correct answer is option C, mutual assent, competent parties, lawful purpose, consideration, and sufficiently definite terms. A valid contract requires agreement and legally sufficient elements, not just informal interest in a property. Choice A is wrong because real estate contracts generally require more definite and documented terms. Choice B is wrong because a deed transfers title and is separate from forming a purchase contract. And choice D is wrong because an MLS reference alone does not establish contract obligations. Question 42. For a duplex in Atlantic City, an offer states that acceptance must be communicated by 5 p.m. Friday. When does acceptance generally become effective? Option A, when the acceptance is properly communicated according to the offer's terms. Option B, when the buyer privately decides to accept. Option C, when the seller starts thinking about the offer. Option D, only after the deed is recorded. The correct answer is option A, when the acceptance is properly communicated according to the offer's terms. Contract formation generally requires objective acceptance communicated in the manner required by the offer. Choice B is wrong because private intent does not notify the offerer. Choice C is wrong because consideration of an offer is not acceptance. And choice D is wrong because recording relates to title notice, not contract acceptance. Question 43. While preparing a listing package, an agreement for the sale of real estate is made orally with no sufficient writing. Which doctrine is most likely involved? Option A, principle of substitution. Option B, rule against perpetuities. Option C, statute of frauds. Option D, doctrine of emblements. The correct answer is option C, statute of frauds. The statute of frauds generally requires real estate sale contracts to be in writing to be enforceable. Choice A is wrong because substitution is an appraisal principle, not a contract writing requirement. Choice B is wrong because that doctrine concerns remote future interests, not the writing requirement for sales contracts. And choice D is wrong because emblements concern crops grown by a tenant. Question 44. At a salesperson training session, a purchase agreement says the buyer may cancel if financing is not approved by a stated date. What is this clause? Option A, a deed covenant of season. Option B, a contingency. Option C, a tax assessment appeal. Option D, a quitclaim deed. The correct answer is option B, a contingency. A contingency makes performance or continued obligation depend on a stated event or condition. Choice A is wrong because that deed covenant concerns ownership title, not a condition in a purchase agreement. Choice C is wrong because an assessment appeal challenges value for taxation. And choice D is wrong because a quitclaim deed transfers whatever interest the grantor has. Question 45. After receiving an offer in Asbury Park, a contract states that deadlines are strict and late performance may be a breach. Which phrase expresses that idea? Option A, caveat emptor. Option B, highest and best use. Option C, quiet enjoyment. Option D, time is of the essence. The correct answer is option D, time is of the essence. The phrase time is of the essence makes timely performance a material contract requirement. Choice A is wrong because that phrase means buyer beware and does not make deadlines strict. Choice B is wrong because that valuation concept concerns the most profitable legal use. And choice C is wrong because quiet enjoyment protects possession from interference, not deadline strictness. Question 46. During an agency disclosure conversation, a seller breaches a valid purchase contract and the buyer wants the court to require transfer of the unique property. Which remedy is the buyer seeking? Option A, subletting. Option B, assemblage. Option C, specific performance. Option D, amortization. The correct answer is option C, specific performance. Specific performance asks a court to enforce the exact contractual promise, often because real estate is considered unique. Choice A is wrong because subletting transfers a tenant's possession interest to another occupant. Choice B is wrong because assemblage combines parcels for development. And choice D is wrong because amortization is loan repayment over time. Question 47. In a compliance audit, a seller grants a buyer the exclusive right to purchase property within 60 days while the seller must keep the offer open. What agreement is this? Option A, a blanket mortgage. Option B, a release deed. Option C, an option contract. Option D, a gross lease. The correct answer is option C, an option contract. An option gives the holder the right, but not the obligation, to buy or lease under stated terms during the option period. Choice A is wrong because a blanket mortgage covers more than one parcel as security. Choice B is wrong because a release deed removes or gives up a claim or interest. And choice D is wrong because a gross lease concerns rent and operating expenses. Question 48. When reviewing closing papers, a kitchen chandelier is physically attached, intended to stay, and adapted to the room. How is it most likely classified? Option A, emblement. Option B, fixture. Option C, trade fixture of a tenant. Option D, personal property that always remains with the seller. The correct answer is option B, fixture. A fixture is personal property that has become part of the real estate through attachment, adaptation, and intent. Choice A is wrong because emblements are cultivated crops. Choice C is wrong because a residential seller's chandelier is not usually a tenant business fixture. And choice D is wrong because attached items intended to stay often become real property. Question 49. Before meeting a client in Patterson, two unrelated buyers own unequal shares of property and each share can pass by will. Which ownership form is most likely? Option A, tenancy in common. Option B, severalty. Option C, joint tenancy with automatic survivorship. Option D, a leasehold estate only. The correct answer is option A, tenancy in common. Tenants in common may own unequal shares and each owner's interest can pass through that owner's estate. Choice B is wrong because severalty means ownership by one person or entity alone. Choice C is wrong because joint tenancy includes survivorship and usually equal ownership interests. And choice D is wrong because a leasehold is a possessory right under a lease, not co-ownership of title. Question 50. During a transaction in Trenton, two owners want the surviving owner to automatically receive the deceased owner's interest. Which ownership feature is needed? Option A, deficiency judgment. Option B, severalty. Option C, divulsion. Option D, right of survivorship. The correct answer is option D, right of survivorship. Right of survivorship causes a deceased co-owner's interest to pass automatically to the surviving co-owner or co-owners. Choice A is wrong because a deficiency judgment follows insufficient foreclosure sale proceeds. Choice B is wrong because severalty involves one owner and no co-owner survivorship. And choice C is wrong because avulsion is a sudden natural change in land. Question 51. In a brokerage file review, a person receives possession and use of property for the duration of another person's life. Which estate is described? Option A, life estate. Option B, easement in gross. Option C, periodic tenancy. Option D, fee simple absolute. The correct answer is option A, life estate. A life estate lasts only for the lifetime of a named person and then ends or passes to the future interest holder. Choice B is wrong because an easement is a use right, not a possessory estate for life. Choice C is wrong because periodic tenancy is a leasehold that renews for successive periods. And choice D is wrong because fee simple absolute is the broadest ownership estate and is not limited by a measuring life. Question 52. For a duplex in Hoboken, a buyer purchases an individual unit and an undivided interest in common areas. Which form of ownership is most likely involved? Option A, easement by necessity. Option B, condominium ownership. Option C, cooperative ownership only. Option D, license only. The correct answer is option B, condominium ownership. Condominium owners hold title to their units plus a shared interest in common elements. Choice A is wrong because that easement provides access and does not create unit ownership. Choice C is wrong because a cooperative usually involves shares in a corporation and a proprietary lease. And choice D is wrong because a license is permission rather than ownership of a unit. Question 53. While preparing a listing package, a driveway easement benefits a neighboring parcel and transfers with that parcel. Which type of easement is this? Option A, encroachment. Option B, easement appurtenant. Option C, a mechanic's lien. Option D, easement in gross for a person only. The correct answer is option B, easement appurtenant. An easement appurtenant benefits land and generally runs with the benefited parcel when ownership changes. Choice A is wrong because an encroachment is an unauthorized physical intrusion. Choice C is wrong because a mechanic's lien secures payment for labor or materials. And choice D is wrong because an easement in gross benefits a person or entity rather than a parcel. Question 54. At a salesperson training session, a neighbor's garage extends 2 feet onto another owner's land. Which title issue is most likely present? Option A, functional obsolescence. Option B, encroachment. Option C, eminent domain. Option D, novation. The correct answer is option B, encroachment. An encroachment occurs when an improvement extends onto another's property without proper right. Choice A is wrong because functional obsolescence is a valuation issue related to design or utility. Choice C is wrong because eminent domain is a government taking for public use. And choice D is wrong because novation substitutes a new party or obligation in a contract. Question 55. After receiving an offer in Morristown, a contractor records a claim against property because the owner did not pay for improvements. Which encumbrance is most likely? Option A, variance. Option B, a mechanic's lien. Option C, literal right. Option D, license. The correct answer is option B, mechanic's lien. A mechanic's lien can secure payment for labor or materials furnished to improve real property. Choice A is wrong because a variance is zoning permission to deviate from rules. Choice C is wrong because literal rights relate to property bordering large bodies of water. and choice D is wrong because a license is permission to use property and does not secure payment. Question 56. During an agency disclosure conversation, a legal description begins at a point of beginning and follows directions and distances around the parcel. Which description method is being used? Option A, lot and block. Option B, datum reference only. Option C, meets and bounds. Option D, street address only. The correct answer is option C, meets and bounds. Meets and bounds descriptions use boundary lines, angles, distances, and a point of beginning. Choice A is wrong because lot and block refers to recorded subdivision map identifiers. Choice B is wrong because a datum is an elevation reference, not a complete boundary description. And choice D is wrong because a street address is not the most reliable legal description. Question 57. In a compliance audit, a deed identifies property as Lot 12, Block 8 on a recorded subdivision map. Which legal description method is this? Option A, government rectangular survey only. Option B, lot and block. Option C, meets and bounds. Option D, informal address description. The correct answer is option B, lot and block. Lot and block descriptions identify parcels by reference to a recorded plat or subdivision map. Choice A is wrong because that system uses principal meridians, baselines, townships, and ranges. Choice C is wrong because meets and bounds relies on courses and distances from a point of beginning. And choice D is wrong because a recorded lot and block is more formal than a street address. Question 58. When reviewing closing papers, a municipality adopts zoning rules to control land use for public welfare. Which government power is being exercised? Option A, taxation. Option B, this cheat. Option C, police power. Option D, eminent domain. The correct answer is option C, police power. Zoning is a classic exercise of police power because it regulates land use to protect health, safety, and welfare. Choice A is wrong because taxation raises revenue rather than directly regulating land use patterns. Choice B is wrong because this cheat applies when property has no lawful owner or heirs. And choice D is wrong because eminent domain involves taking property for public use with compensation. Question 59. Before meeting a client in Newark, the government takes private land for a highway project and pays just compensation. Which power is being used? Option A, private restriction. Option B, eminent domain. Option C, this cheat. Option D, the accretion. The correct answer is option B, eminent domain. Eminent domain allows government to take private property for public use when just compensation is paid. Choice A is wrong because private restrictions are created by deeds or covenants, not government takings. Choice C is wrong because this cheat deals with ownerless property or lack of heirs. And choice D is wrong because accretion is land buildup from natural causes. Question 60. During a transaction in Jersey City, a property owner dies intestate with no heirs, and the property passes to the state. Which government right applies? Option A, police power. Option B, this cheat. Option C, special assessment. Option D, condemnation. The correct answer is option B, is cheat. Is cheat prevents property from remaining ownerless when there are no lawful heirs. Choice A is wrong because police power regulates property use rather than transferring ownerless property. Choice C is wrong because a special assessment pays for a public improvement benefiting property. And choice D is wrong because condemnation is the legal process used in eminent domain. Question 61. In a brokerage file review, a subdivision deed says homes may not be used for commercial auto repair. What type of private control is this? Option A, a title abstract. Option B, a deficiency judgment. Option C, a deed restriction or covenant. Option D, a tax prioration. The correct answer is option C, a deed restriction or covenant. Private deed restrictions and covenants limit how property may be used even when public zoning would otherwise permit the use. Choice A is wrong because a title abstract summarizes recorded title history. Choice B is wrong because a deficiency judgment seeks unpaid debt after foreclosure sale proceeds are insufficient. And choice D is wrong because tax prioration allocates taxes at closing. Question 62. For a duplex in Trenton, a buyer considers land in a mapped flood area and near regulated wetlands. Which issue should trigger extra investigation? Option A, immediate title transfer without due diligence. Option B, automatic exemption from all zoning. Option C, land use and environmental restrictions that may limit development. Option D, guaranteed mortgage approval. The correct answer is option C, land use and environmental restrictions that may limit development. Flood zones and wetlands can affect insurance, development approvals, and lawful use of property. Choice A is wrong because special land conditions usually require more review, not less. Choice B is wrong because environmentally sensitive land is often more regulated, not exempt. And choice D is wrong because environmental concerns do not guarantee financing. Question 63. While preparing a listing package, a salesperson prepares a pricing opinion for a seller using recently sold comparable homes. What is the salesperson most likely preparing? Option A, a deed of trust. Option B, a certified appraisal. Option C, a zoning ordinance. Option D, a comparative market analysis. The correct answer is option D, a comparative market analysis. A comparative market analysis helps estimate a likely listing or sale price using market data but is not a licensed appraisal. Choice A is wrong because a deed of trust is a financing security instrument in some states. Choice B is wrong because a CMA is not the same as a formal appraisal by a certified appraiser. And choice C is wrong because a zoning ordinance is a government land use rule. Question 64. At a salesperson training session, an appraiser estimates value by comparing the subject property to recently sold similar properties. Which approach is being used? Option A, cost approach. Option B, sales comparison approach. Option C, subdivision approach. Option D, income approach. The correct answer is option B, sales comparison approach. The sales comparison approach is based on substitution and uses comparable sales adjusted for differences. Choice A is wrong because the cost approach estimates land value plus replacement or reproduction cost less depreciation. Choice C is wrong because that is a specialized development analysis, not the standard comparable sales method. And choice D is wrong because the income approach converts income into value. Question 65. After receiving an offer in Princeton, an investor's apartment building is valued by converting net operating income into value. Which appraisal approach is being used? Option A, assessed value approach. Option B, income approach. Option C, cost approach. Option D, sales comparison only. The correct answer is option B, income approach. The income approach is commonly used for income-producing properties because investors buy the expected income stream. Choice A is wrong because tax assessments are not one of the three primary appraisal approaches. Choice C is wrong because cost analysis focuses on land and improvements rather than capitalized income. And choice D is wrong because sales comparison uses adjusted sale prices of comparable properties. Question 66. During an agency disclosure conversation, a buyer chooses a loan insured by the Federal Housing Administration. Which statement best describes the loan? Option A, the loan is made directly by the seller. Option B, the loan requires no underwriting. Option C, the loan is guaranteed by the Department of Veterans Affairs. Option D, the loan is made by an approved lender and insured by FHA. The correct answer is option D, the loan is made by an approved lender and insured by FHA. FHA insurance protects the lender and allows qualified borrowers to use FHA program terms. Choice A is wrong because seller financing is separate from FHA-insured lending. Choice B is wrong because FHA loans still involve borrower and property underwriting. And choice C is wrong because VA guarantees eligible veteran loans rather than FHA loans. Question 67. In a compliance audit, a buyer signs a promise to repay the loan and also gives the lender a security interest in the property. Which documents are involved? Option A, deed and bill of sale only. Option B, listing agreement and agency disclosure only. Option C, survey and appraisal only. Option D, promissory note and mortgage. The correct answer is option D, promissory note and mortgage. The note is the borrower's debt promise, while the mortgage secures that debt with real property. Choice A is wrong because a deed transfers title and a bill of sale transfers personal property. Choice B is wrong because brokerage documents do not create the borrower's debt and security pledge. And choice C is wrong because surveys and appraisals provide information but do not create the loan obligation. Question 68. When reviewing closing papers, a lender requires private mortgage insurance because the borrower has a small down payment. Which purpose does PMI serve? Option A. It replaces the need for a promissory note. Option B. It protects the lender if the borrower defaults on a high LTV conventional loan. Option C. It protects the borrower from losing equity if prices decline. Option D. It guarantees that property taxes will not rise. The correct answer is option B. It protects the lender if the borrower defaults on a high LTV conventional loan. Private mortgage insurance is commonly required when lender risk is higher because the borrower has limited equity. Choice A is wrong because the borrower still signs a debt obligation. Choice C is wrong because PMI is lender protection, not market loss insurance for the borrower. And choice D is wrong because PMI has no effect on tax assessments. Question 69. Before meeting a client in Asbury Park, a lender provides the loan estimate and closing disclosure under Federal Integrated Disclosure Rules. Which topic is involved? Option A. A broker price opinion only. Option B. A zoning variance. Option C. TRID disclosure requirements. Option D. A deed restriction. The correct answer is option C. TRID disclosure requirements. TRID rules integrate federal mortgage disclosures so borrowers receive clearer information about loan terms and closing costs. Choice A is wrong because pricing opinions do not replace loan disclosure rules. Choice B is wrong because a variance is land use permission from a local authority. And choice D is wrong because deed restrictions are private limits on property use. Question 70. During a transaction in Montclair, a creditor refuses to consider an applicant's income because of the applicant's marital status. Which federal credit law is implicated? Option A. Municipal Land Use Law. Option B. Truth in Renting Act. Option C. Equal Credit Opportunity Act. Option D. Real Estate Settlement Procedures Act. The correct answer is option C. Equal Credit Opportunity Act. The Equal Credit Opportunity Act prohibits discrimination in credit transactions based on protected factors. Choice A is wrong because that law concerns local land use planning and approvals. Choice B is wrong because that is a New Jersey landlord-tenant disclosure law. And choice D is wrong because RESPA focuses on settlement practices and certain referral issues, not all credit discrimination. Question 71. In a brokerage file review, a title search finds an unreleased old mortgage that may affect ownership. What is this issue commonly called? Option A. Functional obsolescence. Option B. A gross lease. Option C. A variance. Option D. A cloud on title. The correct answer is option D. A cloud on title. A cloud on title is a claim, defect, or unresolved matter that may impair marketable title. Choice A is wrong because functional obsolescence is a loss in value from outdated design or utility. Choice B is wrong because a gross lease concerns rent payment structure. And choice C is wrong because a variance is zoning relief and does not clear title. Question 72. For a duplex in Jersey City, a buyer wants assurance against certain hidden title defects after closing. Which product is designed for that purpose? Option A. A home warranty only. Option B. Title insurance. Option C. Hazard insurance only. Option D. Private mortgage insurance. The correct answer is option B. Title insurance. Title insurance protects against covered title defects that may not be discovered before closing. Choice A is wrong because a home warranty addresses covered systems or construction issues, not ownership title. Choice C is wrong because hazard insurance covers physical damage risks, not title defects. And choice D is wrong because PMI protects the lender from borrower default. Question 73. While preparing a listing package, a deed is signed, delivered, and accepted by the grantee. When does title generally pass? Option A. Only when the buyer first tours the property. Option B. Upon valid delivery and acceptance of the deed. Option C. Only when the listing agreement is signed. Option D. Only when the property is advertised online. The correct answer is option B. Upon valid delivery and acceptance of the deed. A deed transfers title when it is properly executed, delivered, and accepted. Choice A is wrong because a showing creates no title transfer. Choice C is wrong because a listing agreement authorizes brokerage services and does not transfer title. And choice D is wrong because advertising does not convey ownership. Question 74. At a salesperson training session, a deed contains no warranties and transfers only whatever interest the grantor may have. Which deed is most likely? Option A, quitclaim deed. Option B, bargain and sale deed with covenants. Option C, general warranty deed. Option D, installment land contract. The correct answer is option A, quitclaim deed. A quitclaim deed conveys any interest the grantor has without promising that title is valid. Choice B is wrong because that deed contains limited assurances beyond a quitclaim. Choice C is wrong because a general warranty deed provides broad title warranties. And choice D is wrong because that is a financing arrangement, not a deed type. Question 75. After receiving an offer in Camden, a buyer records a deed promptly after closing. What is the main purpose of recording? Option A, to give public notice of the buyer's interest. Option B, to set the zoning classification. Option C, to make an invalid deed automatically valid. Option D, to create the buyer's loan obligation. The correct answer is option A, to give public notice of the buyer's interest. Recording protects the buyer by making the ownership claim part of the public record. Choice B is wrong because zoning is controlled by municipal regulation. Choice C is wrong because recording does not cure all defects in execution or delivery. And choice D is wrong because the note creates the debt obligation. Question 76. During an agency disclosure conversation, a lender forecloses because the borrower defaults and the sale proceeds do not fully cover the debt. Which term may describe the remaining unpaid amount? Option A, deficiency. Option B, accession. Option C, estoppel certificate. Option D, equity. The correct answer is option A, deficiency. A deficiency is the remaining debt when foreclosure sale proceeds are not enough to satisfy the obligation. Choice B is wrong because accession concerns property added by natural or artificial means. Choice C is wrong because an estoppel certificate confirms facts such as lease status. And choice D is wrong because equity is the owner's value above liens, not unpaid debt after sale. Question 77. In a compliance audit, a seller owes more on the mortgage than the property is expected to sell for and asks the lender to approve a reduced payoff. What transaction is being discussed? Option A, tax assessment appeal. Option B, installment sale with no lender involvement. Option C, adverse possession. Option D, short sale. The correct answer is option D, short sale. A short sale requires lender cooperation because the sale price will not fully satisfy the mortgage debt. Choice A is wrong because an assessment appeal challenges taxable value, not lender payoff. Choice B is wrong because a short sale specifically involves lender approval of less than the full payoff. And choice C is wrong because adverse possession is acquiring title through possession under strict requirements. Question 78. When reviewing closing papers, a tenant pays one fixed rent amount and the landlord pays most operating expenses. Which lease type is most likely? Option A, gross lease. Option B, percentage lease. Option C, ground lease. Option D, net lease. The correct answer is option A, gross lease. In a gross lease, the tenant generally pays a fixed rent while the landlord covers specified property expenses. Choice B is wrong because a percentage lease includes rent based partly on business sales. Choice C is wrong because a ground lease usually leases land for long-term development. And choice D is wrong because a net lease shifts some or all property expenses to the tenant. Question 79. Before meeting a client in Morristown, a retail tenant pays base rent plus a share of gross sales. Which lease type is this? Option A, percentage lease. Option B, life estate. Option C, gross lease. Option D, graduated deed. The correct answer is option A, percentage lease. Percentage leases are common in retail settings because rent is tied partly to the tenant's business performance. Choice B is wrong because a life estate is an ownership estate rather than a lease. Choice C is wrong because a gross lease uses a fixed rent structure without a sales percentage as the defining feature. And choice D is wrong because that is not a standard lease type. Question 80. During a transaction in Edison, a property manager holds rent deposits and security funds for an owner. Which duty is central to that role? Option A, guaranteeing future property appreciation. Option B, fiduciary accounting and safeguarding of funds. Option C, using trust funds to pay personal bills. Option D, ignoring owner instructions whenever convenient. The correct answer is option B. Fiduciary accounting and safeguarding of funds. Property managers handle other people's property and money, so fiduciary care and accurate accounting are essential. Choice A is wrong because a manager cannot guarantee market value increases. Choice C is wrong because personal use of client funds is conversion, and choice D is wrong because a manager owes duties to the owner under the management agreement. Question 81. In a brokerage file review, a leasing office refuses to provide a reasonable accessibility accommodation for a qualified applicant with a disability. Which compliance area is implicated? Option A. Only fixture classification. Option B. Only tax prioration. Option C. Fair housing and aid-related property management duties. Option D. Only capitalization rate analysis. The correct answer is option C. Fair housing and aid-related property management duties. Property management must comply with fair housing and accessibility requirements when dealing with applicants and tenants. Choice A is wrong because fixture law does not excuse discriminatory leasing practices. Choice B is wrong because tax allocation does not address disability accommodation. And choice D is wrong because income valuation does not resolve accommodation duties. Question 82. For a duplex in Montclair, a seller says there is no need to disclose lead-based paint information for a home built in 1965. Which response is best? Option A. Lead disclosure is optional if the seller dislikes paperwork. Option B. Lead disclosure applies only to vacant land. Option C. Lead-based paint disclosures are required for many residential properties built before 1978. Option D. Lead disclosure applies only to newly constructed homes. The correct answer is option C. Lead-based paint disclosures are required for many residential properties built before 1978. Federal lead-based paint rules are a key property disclosure topic for older residential housing. Choice A is wrong because disclosure duties are not waived by convenience. Choice B is wrong because the rule concerns certain residential dwellings, not vacant parcels, and choice D is wrong because newer construction is generally less likely to trigger the federal pre-1978 rule. Question 83. While preparing a listing package, a buyer asks whether marketable title and insurable title mean exactly the same thing. Which answer is best? Option A. A marketable title refers only to zoning. Option B. They always mean no title issues exist anywhere. Option C. They are related but not identical because a title company may insure some risks that still require review. Option D. Insurable title means the deed was never recorded. The correct answer is option C. They are related but not identical because a title company may insure some risks that still require review. Marketable title focuses on reasonable freedom from defects, while insurable title focuses on what a title insurer is willing to insure. Choice A is wrong because marketability concerns ownership title, not just land use. Choice B is wrong because even insured titles can have exceptions or exclusions. And choice D is wrong because insurability does not depend on avoiding recording. Question 84. At a salesperson training session, a listing agreement gives one broker the exclusive right to earn a commission if the property sells during the listing period. Which listing type is described? Option A. Exclusive right to sell listing. Option B. Open listing only. Option C. Option contract. Option D. Net listing. The correct answer is option A. Exclusive right to sell listing. An exclusive right to sell listing gives the listing broker the strongest commission protection during the listing term. Choice B is wrong because an open listing allows multiple brokers and only the procuring broker earns commission. Choice C is wrong because an option gives a right to buy rather than appointing a listing broker. And choice D is wrong because a net listing pays the broker amounts above a seller's desired net and raises legal and ethical concerns. Question 85. After receiving an offer in Patterson, a buyer asks whether all commission rates are fixed by New Jersey law. Which answer is best? Option A. Only listing brokers may negotiate commissions and buyers never may. Option B. Commission is illegal in all residential sales. Option C. Commission rates are negotiable between the parties and the brokerage. Option D. The commission sets a mandatory statewide commission. The correct answer is option C. Commission rates are negotiable between the parties and the brokerage. Antitrust and consumer protection principles require avoiding claims that commissions are fixed or uniform. Choice A is wrong because compensation terms depend on the applicable agreement. Choice B is wrong because licensed brokerage compensation is permitted when properly earned and disclosed, and choice D is wrong because state law does not set a mandatory brokerage commission rate. Question 86. During an agency disclosure conversation, several brokers agree not to charge below a certain commission rate. Which legal concern is most direct? Option A, price fixing under antitrust law. Option B, easement by necessity. Option C, adverse possession. Option D, prioration. The correct answer is option A, price fixing under antitrust law. Competitors may not agree to set commission rates because such agreements restrain competition. Choice B is wrong because that easement provides access to landlocked property. Choice C is wrong because adverse possession concerns acquiring title through possession. And choice D is wrong because prioration allocates expenses at closing. Question 87. In a compliance audit, brokers divide a city and agree that each will work only in assigned neighborhoods. Which antitrust violation is suggested? Option A, substitution principle. Option B, specific performance. Option C, tie-in survey. Option D, a market allocation. The correct answer is option D, market allocation. Market allocation occurs when competitors divide customers or territories instead of competing freely. Choice A is wrong because substitution is a valuation concept. Choice B is wrong because specific performance is a contract remedy. And choice C is wrong because that is not the standard term for dividing markets. Question 88. When reviewing closing papers, a buyer asks why due diligence matters before buying a property near the Pinelands. Which New Jersey topic is most relevant? Option A, Pinelands Protection Act and land use restrictions. Option B, only commission splitting. Option C, only private mortgage insurance. Option D, only fixture ownership. The correct answer is option A, Pinelands Protection Act and land use restrictions. Special New Jersey land use laws can affect development rights and permissible uses in protected areas. Choice B is wrong because compensation issues do not decide environmental land use limits. Choice C is wrong because PMI does not address protected land use areas. And choice D is wrong because fixture law does not control regional environmental regulation. Question 89. Before meeting a client in Princeton, a landlord must provide certain required rental information to tenants under New Jersey law. Which topic is most relevant? Option A, eminent domain. Option B, general warranty deed. Option C, Truth in Renting Act. Option D, real estate guarantee fund. The correct answer is option C, Truth in Renting Act. The Truth in Renting Act is a New Jersey landlord-tenant disclosure topic included in state law review. Choice A is wrong because eminent domain is a government taking, not tenant disclosure. Choice B is wrong because deeds transfer title and do not provide rental notices. And choice D is wrong because the fund addresses certain losses from licensee misconduct. Question 90. During a transaction in Atlantic City, a buyer asks whether freshwater wetlands on a parcel can affect construction plans. Which New Jersey topic is most relevant? Option A, net lease. Option B, discount points. Option C, joint tenancy. Option D, a Freshwater Wetlands Protection Act. The correct answer is option D, Freshwater Wetlands Protection Act. Freshwater wetlands regulation can restrict development and require permits or approvals before construction. Choice A is wrong because net leases allocate property expenses between landlord and tenant. Choice B is wrong because discount points are prepaid loan interest charges. And choice C is wrong because joint tenancy is a form of co-ownership. Question 91. In a brokerage file review, a buyer purchases a property for $335,000 and obtains a mortgage loan of $257,950. What is the loan-to-value ratio? Option A, 67%. Option B, 87%. Option C, 77%. Option D, 23%. The correct answer is option C, 77%. Loan-to-value is the loan amount divided by the purchase price, so $257,950 divided by $335,000 equals 77%. Choice A is wrong because that divides by the wrong property value. Choice B is wrong because that overstates the ratio by adding an unrelated percentage. And choice D is wrong because that calculates the down payment percentage rather than the loan-to-value ratio. Question 92. For a duplex in Edison, a borrower pays 3 discount points on a $250,000 loan. How much do the points cost? Option A, $75,000. Option B, $83,333. Option C, $7,500. Option D, $10,000. The correct answer is option C, $7,500. 1 discount point equals 1% of the loan amount, so 3 points equals 3% of $250,000, or $7,500. Choice A is wrong because that treats each point as 10% instead of 1%. Choice B is wrong because that divides by the point number instead of multiplying by the point percentage, and choice D is wrong because that uses the wrong number of discount points. Question 93. While preparing a listing package, a listing sells for $475,000 with a total commission rate of 5.5%. What is the total commission? Option A, $30,875. Option B, $2,613. Option C, $448,875. Option D, $26,125. The correct answer is option D, $26,125. Total commission is sale price multiplied by the commission rate, so $475,000 times 5.5% equals $26,125. Choice A is wrong because that uses a commission rate 1 percentage point too high. Choice B is wrong because that moves the decimal point incorrectly. And choice C is wrong because that calculates approximate seller proceeds before other costs rather than commission. Question 94. At a salesperson training session, a property sells for $520,000. The total commission is 6%, and a salesperson receives 55% of the brokerage's commission. What is the salesperson's share if this is the only split applied? Option A, $31,200. Option B, $17,160. Option C, $286,000. Option D, $14,040. The correct answer is option B, $17,160. First calculate the total commission of $31,200, then multiply by the 55% split to get $17,160. Choice A is wrong because that gives the full commission before the split. Choice C is wrong because that applies the split percentage to the sale price instead of the commission. And choice D is wrong because that gives the other side of the split. Question 95. After receiving an offer in Newark, annual property taxes are $7,500 and the seller owes taxes for 125 days using a 365-day proration method. What is the seller's tax proration? Option A, $4,931.51. Option B, $2,604.17. Option C, $2,568.49. Option D, $78,125. The correct answer is option C, $2,568.49. Daily taxes are $7,500 divided by 365, and multiplying by 125 days gives $2,568.49. Choice A is wrong because that gives the remaining annual taxes instead of the prorated amount. Choice B is wrong because that uses a 360-day year rather than the stated 365-day method, and choice D is wrong because that treats days as months. Question 96. During an agency disclosure conversation, a buyer purchases a home for $410,000 and makes an 18% down payment. How much is the down payment? Option A, $6,150. Option B, $73,800. Option C, $94,300. Option D, $336,200. The correct answer is option B, $73,800. The down payment equals the purchase price multiplied by 18%, which is $73,800. Choice A is wrong because that divides the down payment as though it were a monthly payment. Choice C is wrong because that uses the wrong down payment percentage. And choice D is wrong because that calculates the amount financed rather than the down payment. Question 97. In a compliance audit, A seller's sale price is $580,000, mortgage payoff is $320,000, and closing costs are $19,000. What are the seller's estimated net proceeds before other adjustments? Option A, $339,000. Option B, $241,000. Option C, $260,000. Option D, $561,000. The correct answer is option B, $241,000. Seller net is sale price minus the mortgage payoff and closing costs, so $580,000 to $320,000, $19,000 equals $241,000. Choice A is wrong because that adds deductions instead of subtracting them from the sale price. Choice C is wrong because that omits closing costs, and choice D is wrong because that omits the mortgage payoff. Question 98. When reviewing closing papers, an income property has net operating income of $65,000 and a value of $800,000. What is the capitalization rate? Option A, 10.12%. Option B, 8.12%. Option C, 81.25%. Option D, 12.31%. The correct answer is option B, 8.12%. Capitalization rate is net operating income divided by value. So $65,000 divided by $800,000 equals 8.12%. Choice A is wrong because that adds an unrelated percentage to the calculation. Choice C is wrong because that shifts the decimal place incorrectly. And choice D is wrong because that divides value by income and does not produce a capitalization rate. Question 99. Before meeting a client in Camden, a monthly mortgage payment includes $1,520 for principal and interest, $540 for taxes, and $145 for insurance. What is the pity payment? Option A, $2,205. Option B, $1,665. Option C, $2,060. Option D, $685. The correct answer is option A, $2,205. Pity includes principal, interest, taxes, and insurance, so adding $1,520, $540, and $145 gives $2,205. Choice B is wrong because that omits taxes. Choice C is wrong because that omits insurance. And choice D is wrong because that omits principal and interest. Question 100. During a transaction in Hoboken, a rectangular parcel measures 125 feet by 84 feet. What is its area? Option A, 10,500 square feet. Option B, 418 square feet. Option C, 0.24 square feet. Option D, 209 square feet. The correct answer is option A, 10,500 square feet. Area is length multiplied by width, so 125 feet times 84 feet equals 10,500 square feet. Choice B is wrong because that calculates perimeter instead of area. Choice C is wrong because that converts to acres but labels the result incorrectly. And choice D is wrong because that adds dimensions rather than multiplying them.